This is our process. We're not going to deviate. Hi, Jeff Marsaci, the Plain English Attorney, and today I'm going to talk about dealing with real estate in revocable living trusts. Now, this is going to be a kind of redo of an older video that I did in the subject because it kind of needs to be updated, and on YouTube the sound quality wasn't great. So we're just going to go ahead and work this new video on that same subject and cover the same materials. So really we're talking about having real estate inside your revocable living trust, and now there's a transaction that needs to happen. Whether you're buying a new property into the name of the trust, you're selling property out of your trust, or you're refinancing a mortgage on real estate that's inside a trust. All right, so let me first address something that comes up occasionally, and this was actually a question from a fellow estate planning attorney. She was kind of getting online screamed at. Well, I just don't know why anybody would put the, if you've got a husband and wife, why you would put that in a revocable trust. Why would you put their real estate in there? Because it's better to have tenancy by the entirety because it's got lawsuit protection. All right, what exactly did that mean? And she was asking me, how do I respond to this? Well, okay. When you have a husband and wife and they own real estate as tenancy by the entirety, there's lawsuit protection, there's creditor protection. If there's something only affecting one of the two, that means husband went out and got into a car accident and they're suing, and they've actually, this lawsuit is exceeding the limits on the auto policy, then, they can't take the house away from the wife, the spouse. That's just not fair. So there's that creditor protection. Oh, well, I mean, that sounds reasonable, right? Yeah, okay. What are the odds that someone's going to have a lawsuit that's going to exceed their insurance limits, and this lawsuit isn't going to involve the spouse in some way? Or if it's a creditor just coming after the husband and the spouse never had to sign agreeing to some type of loan and recovery, what are the odds that's going to happen? Very, very small. And if that is an issue, the insurance limits are really low. Well, you need to get better coverage on your insurance. Now, let's weigh that against what are the odds you're going to die ever? Well, that's 100%. So saying, you need to have this creditor protection in this very, 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 very unlikely event versus you're going to die someday and this could end up being an issue with probate or with settling the estate and having to deal with that real estate. The odds just aren't there. Now, what are some of the effects of moving your real estate into the revocable trust and then you pass on? All right, well, then the house can be sold with just the trustee handling it. And gosh, I've seen this so many times. You got 4 kids, they're spread out all over the country, and it was not put into a revocable trust. And now the buyer's mortgage company is insisting that all 4 of the kids have to sign this stuff on the same day, preferably in the same place. Well, look, if it's in a revocable trust and you've got one successor trustee, which we recommend one person at a time, then they get to just sign the paperwork to sell the house as part of that trust estate. Done. What if you have real estate outside of North Carolina? And I'm talking about North Carolina as an example, but in a lot of other states, it's the same way. If you live in one state, but you have real estate in other states, well, your quote probate is in North Carolina. They will have that real estate have an ancillary probate proceeding in that county, in that state. And if you have 3 or 4 properties in that other state, that's 3 or 4 other ancillary probates. Well, why would you deal with that? Well, you don't want to. So you would have that real estate in your trust and it's done. Okay, so that's what we have to deal with when on the question of whether or not to put it in. The other thing is, and sometimes I hear this, oh, you can't do that. That violates the due on sale clause and you're going to have to pay all the money on your mortgage. No, there's actually federal legal protection that prevents that. Now, if it's, again, it has to be like an individual putting it into their individual trust, or a married couple who's signed off on the mortgage, putting it into their joint revocable living trust, then it's fine. It's not violating any due on sale clause and the mortgage just continues. All right, so let's get into these other transactions that I mentioned. If you're buying a piece of real estate and you want it titled in your revocable living trust, which is, again, how we recommend this happens, then if it's a cash sale, it's not an issue. You know, the real estate attorney just needs to have the proper name of the trust. So once it's purchased, again, for cash, it's done. The minute you get a mortgage company involved, now suddenly there's more that has to happen. Oh, we need to cert this trust certification form. We need an attorney opinion letter. We need this, blah, blah, blah. Well, in a lot of cases, the mortgage company or the real estate professionals involved in the transaction, they've got all the paperwork. So this is really more for those rare instances where I've found people just trying to push something off onto the estate planning attorney, and we end up with some issues around, well, what paperwork do you need? Now, on the buying the real estate, which just ends up being much easier, is just buy the real estate in your name or for a couple in your names, and then come back to me and we can quit claim deed that into the trust afterwards. Now, this is what most mortgage companies are not going to tell you. They really don't care. As long as the paperwork showing you owe them the money gets filed first. So as long as you do that and you keep making your payments, the mortgage company is fine. So that's really what they're concerned about, is making sure their legal paperwork is filed first. What they have also a legitimate concern about is they don't want you to be able to put this into a trust, and somewhere in the trust, you're not personally going to be on the hook for paying the mortgage. So again, purchasing it in your name or names and then deeding it into the trust might just be the easier way to do it. All right, so second situation, you're selling real estate out of your revocable living trust. Again, most of the time, the mortgage company for the buyer, that and with the other real estate professionals, they'll have whatever forms are needed, and it's only in, well, really 8, 9, 10 times a year that we end up with them trying to push additional paperwork onto the estate planning attorney. And it's usually in the form of we need a trust certification form or an attorney opinion letter. I'll get to that in a minute. But when you're selling real estate, that mortgage company, they have the same concerns as if you were buying that real estate. They need to make sure there's nothing in the trust that's going to affect their claim on the property that you're selling to someone else. So it's actually much more rare, maybe once a year. And this is totally the mortgage company and what they want. It just becomes easier to deed it out of your trust and into your individual name as you're selling the property. Okay, now in terms of your estate planning, you take the proceeds and you put it into an account that's already in the name of your trust, and your estate planning end of it is fine. So, all right, so that's you're selling real estate out of your trust to someone. And now the third issue, and I have no idea why it's this complicated for this particular situation. It's when you're refinancing a mortgage that's inside the trust. At some point, you had all the credit checks, you secured a mortgage, and now you're just refinancing. Usually in this situation, it's just to get a better rate. That's when I sometimes see we need all this other additional paperwork, and it becomes more complicated than even the sale or the purchase of real estate in or out of the trust becomes so. All right, that also happens. And again, they request a trust certification form or an attorney opinion letter, or they need to see certain things. All right, so now let's get into exactly what is that paperwork that they're requesting. Sometimes it's just a copy of the trust. And okay, you just have to decide, are you all right giving them a copy of the trust? Part of our process when we're doing the estate planning documents and signing everything, it's done at least in duplicate for most of those documents, and then we keep an original set and we scan it. All right, we offer that scanned PDF to the clients, and sometimes they take it. So it may just be, hey, I'm selling my house and they want a copy of the trust. I can't put my hands on it right now. All right, well, we can email a copy of that scanned PDF to the company, and maybe it's done at that point. Other times it's, we need a trust certification form, or we need an attorney opinion letter. Now, the trust certification form, I have a whole other video, a trust certification clown show, and it's kind of enlightening because this does happen several times a year. What is the usual process? Again, only in those instances where they're trying to push this off onto the estate planning attorney. They make it sound like it's just this form that the attorney's got ready and all lined up. And okay, well, a trust certification form is the trustees certifying that certain things are true. Well, what things? Oh, it's a trust certification form. Look, if you're telling somebody to swear something under oath that certain things are true, you have to tell them what those certain things are. That just makes sense. If the mortgage company is looking for 8 things, then they need to tell us, okay, these are the 8 things that need to be in the trust certification form. And if they do that, and that does happen sometimes, great. We'll just put it in, send it, and it's done. So it's nice and easy. The attorney opinion letter, same thing. Look, you need my opinion on something. Do you really want me to just bill my clients at a high hourly rate for legal services to put in an attorney opinion letter that I like French vanilla ice cream? No, you need to tell me what you need to see, and it's that same 8 things. Fine. What is usually happening, and why this becomes such a frustration for my office and my staff and for me, is they're not telling us what they need to see in those forms. They won't put in writing what needs to be in those forms. So they're telling me or telling one of my staff members, oh, it needs to say these 4 things. Well, can you put that in an email? No, I don't have time. It just needs to have those 4 things. Okay, and this may be a month or 6 weeks ahead of time. And then invariably, 2 or 3 days before the closing, I can't believe you messed this up. It only has these 4 things. We need these other 4 things. How could you mess this up? Well, you never told us you needed those things. And now my office is expected to drop everything for all of our other clients to redo the paperwork. Now, do our clients want to pay us again to redo that stuff? No. Well, why can't they just tell us these are the 8 things? This is where the issue comes up, that it becomes so frustrating for us and our clients. And often the real estate professionals are making it sound like it's the law office's fault. It's our fault that they never told us what these things are. All right. So what exactly do we do? This is our process. We're not going to deviate. We have a series of videos that are going to be listed in an email. We have a memo that outlines exactly what we need. And if you provide that to us, we're happy to handle this. Because now we have in writing what you want. We can do this paperwork correct the first time and get it in. I don't know why it's that difficult. I don't know why they're just saying, oh, just get a trust certification form. And I'm going to make this other point on a trust certification form, and it's in the video, a trust certification clown show. All right. You need to, that trust certification form is just a 1-page form that summarizes the terms of the trust. This can be anywhere from a 70 to 120 page document. Summarize what? Again, if you're not clear, we can't provide what you're looking for to be in that paperwork. So if anyone says, oh yeah, the estate planning attorney has it, it's just a summary of the terms of the trust. No, there could be hundreds of things that potentially they want to see in there. There's no one form that we can just send you. It's got to be what they're in particular looking for. So again, this, you can tell this becomes a frustrating thing because it's like going up and ordering food at a restaurant and saying, bring me food, and then complaining when it's not exactly what you wanted. Okay, we need exactly what they need to make this happen. So I hope you found that information useful. We are going to have other related videos, and we're going to have that in that letter as well as the descriptions below to link to these other videos. So as always, for my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.